Hello everyone, this is chapter 19 for business law. The first thing that we talked about in this chapter was the types of damages. So there's 4 categories. Those include the compensatory, consequential, punitive, and nominal. The first one is compensatory, so this covers direct losses and costs. This is used to compensate partly who suffered the losses. And then we have consequential. So this covers indirect and forcible losses. And then we have punitive. So this punishes and deters the wrongdoing. And then we have nominal. So this recognizes the wrongdoing when no monetary loss is shown. So the first one we have is compensatory damages. So this basically compensates non-breaching party for the loss of the bargain and replace what was lost because of the wrongdoing or the damage. Then this comes along with standard measures. So this is the difference between value of promised performance and the value of actual performance in the contract. And then consequential, this is breaching party knew that the special circumstances would cause the non-breaching party to suffer additional loss. And then the third one is punitive. So this may be available when an action causes both a breach of contract and a tort. And then lastly, we have nominal. So this is essentially no financial loss. And then we have the mitigation of damages. So this is the duty of the innocent injured party to reduce the damages that he or she had suffered. And then rental agreement, this is when the landlord must use reasonable means to find a new tenant if previous tenant defaults on rent and abandons the premises. And then we have employee contracts. So this is when a person who is wrongfully terminated owes a duty to take a similar job if one is available. And then we have the liquidated damages versus the penalties. So liquidated damages, this is the specified amount agreed to be paid as damages in the event of future breach of the contract. And then we have penalties. So this is designed to penalize. These are usually unenforceable. And then we have equitable remedies. So these include rescission, restitution, specific performance, and reformation. So first we have the rescission and restitution. So this is cancellation of a contract in order to return the parties to their pre-contract position. And then we have the reformation. So this allows the contract to be rewritten to reflect the parties' true intentions in the contract. This is usually used when there are mistakes in the contract. And then the last thing we have is the waiver. So this is knowing relinquishment of a legal right to require satisfactory and full performance. The consequences of a waiver of breach. So this is when a waiver occurs. The party waiving the breach cannot take any later action on it. And that is chapter 19 for business law.